We're now caught up and on section 6. And we have to talk about motions to dismiss tonight in a couple of cases. And I do want to mention to you that for next class, I hope to be back, but I am on the Human Rights Commission at Baldpate Hospital. And they meet quarterly, and their meeting is next Thursday. If it runs long, I will call front office and have them tell you that. And if so, it doesn't look like I'll get back, I'll let them know that. We'll finish the cases that we have the next time we meet. But I hope and anticipate that we'll get back. It's just I don't know the agenda yet. So part of it depends on how lengthy the agenda is and how what's been going on at the hospital in that time period. So we'll have to play it somewhat by ear. But let's talk a little bit about motions to dismiss under Rule 12, which ends up being a really important motion for a bunch of different reasons in civil litigation. One of the main reasons, and it's not the reason why it's used, but it has some real benefit here, is that when I file a motion to dismiss under Rule 12, it delays the time I'm required to file an answer. So a motion to dismiss, until that motion is acted upon, I don't have to file an answer. And so what sometimes it's helpful is, in order for you to be able to gather additional information and facts, in order to plead either the answer and or any counterclaim that you might plead. So you really should start to think about the motion to dismiss as a useful tool in your arsenal. You know, I call it the first of your 3 testing motions, and it can test various procedural and substantive deficiencies in the complaint. Are we in the right court? Has the defendant been properly served? Is this the right forum that the defendant can be accountable in? Is it the appropriate venue? Are there problems with the complaint itself? And it's not just the complaint. I know when I talk to you guys about the rule, I always say the complaint. But more often than not, there are multiple counts in most civil complaints. It's usually never a simple count, breach of contract. If we've got a breach of contract, oftentimes we look to see, can we add a 93A count in there you saw for either business v. business context or business v. consumer or consumer v. business type of situation. And if we're going to plead various federal rights that we might have, we might also, almost always likely to plead some state actions in that complaint as well. What you're supposed to do when you plead matters in a complaint is look to try and really uncover the various legal theories that might justify relief for your client. And more often than not, you have multiple counts, whether it's intentional infliction of emotional distress, negligence, false imprisonment, whatever it is, you have various counts in that complaint. Well, a motion to dismiss can be used to test and see whether some of those counts shouldn't survive the motion to dismiss. So if I'm facing 6 counts, then maybe what I might bring a motion to dismiss to combat various of those counts as to why they shouldn't survive a motion to dismiss. And that may seem to you like, well, why bother if the most of the counts are going to survive? Well, because depending on what counts survive, that's going to talk about also, to some extent, the scope of discovery, right? The scope of discovery is anything that's relevant or that which will lead to relevant information which isn't otherwise privileged. Well, if I throw out your false imprisonment and your kidnapping count, and all we've got left is a negligence count, well then your discovery should focus on that. And then ultimately what goes to trial should have to focus on those issues as well. So we're narrowing the scope of the plaintiff's both discovery and the action that they can try at trial. And it's not uncommon that when people plead in their complaint multiple counts, obviously some of them are weaker than others. And if they have failed to state a cause of action either factually or legally, I think it is your obligation to try and throw out those counts. For instance, it's not uncommon in Massachusetts to plead a 93A count if we've got a 93A claim that we can make with a straight face. Well, the problem with the 93A count is that from the defendant's perspective, losing on that count means I pay at least double damages plus attorney's fees. And so that gives the plaintiff real leverage if that count exists and is able to go to trial. Well, if I can knock that out because in a consumer v. business context, it has to be preceded by a 30-day demand, and you didn't make that 30-day demand letter, well, then that counts up. And I can move to dismiss it because you failed to follow the statutory prerequisites. And I do think that that's your job as the defendant's advocate to cut out the causes of action that are weaker, assuming not just weaker, but can't survive the motion to dismiss legally or factually, and go to court, go to trial on a narrower case against your client. And I also think from a strategic standpoint, if you're defending, anytime I can weaken the strength of the plaintiff's case and make them look more weak, and make them look like they've overreached in coming after me, even better, because now I'm going in, gaining ground, gaining momentum as we go forward when the court agrees with my legal position that counts 2, 6, and 8 should be gone. Of course, this still leaves 5 other counts in the complaint, any one of which will be enough to win. But the fact is that there are oftentimes, especially in a multiple count complaint, there may be some counts that won't survive, legitimately won't survive a motion to dismiss. Questions on motions to dismiss? When I call it the testing motion, the idea is that sometimes you look at a count and you look at a cause of action, or you look at the action itself as to where it's filed, and you think that there may be either procedural or substantive deficiencies with it. Why not test that? Why not test and see if you're accurate, and see if the judge agrees with you that some of these counts shouldn't survive? And if you are successful, you've narrowed the reach of the plaintiff's action. But
so could you, as kind of a matter of course, use a motion to dismiss to extend your time? Because doesn't it toll your time to answer?
It does. I don't know whether I'd do it as a matter of course, because remember, any document you file with the court is subject to Rule 11. But as long as you can make the argument with a straight face that there may be procedural or substantive deficiencies, then you should do it. But it does give you, from the other standpoint, filing the motion to dismiss allows you to investigate the case fully, as Rule 11 requires, and to marshal the evidence so that you can either answer fully or file an answer and, in fact, a counterclaim against the other side. So I won't agree with as a matter of course, because I don't think you should just do things routinely. I think you need to think about whether it lies or not. But I think there's very few claims that are so clearly legally and factually established that oftentimes it doesn't. Oftentimes you can find a way to make use of a motion to dismiss. Let me put it this way. I think from my experience, I've probably seen it in about half the cases that I have. That sometimes they'll just file an answer if it's so clear and it's a relatively narrow complaint. Other times when you've got a number of counts, and all the counts are not as solid as each other, you will see someone take the chance to move to dismiss various counts. I'd say it's utilized in about half the time. As is summary judgment, by the way, from the same standpoint as the defendant. I almost don't understand, with the modern standard of summary judgment, why more defense attorneys don't file summary judgment, because it's a pretty elastic standard, even though the rule doesn't seem to indicate it is. So I would do that more often as well, but I see that used in about half the cases. Okay? Questions on motion to dismiss? The big key, pointed out, is it gives you time to marshal the information so that you can properly file an answer. Otherwise, you're going to file an answer in all likelihood, deny. But remember to plead your affirmative defenses, and remember to really investigate it. The problem is, you have 20 days to file an answer. Oftentimes, you haven't even seen that client until the last of those, the second half of those 10 days. And you got to make your fee arrangements, you got to do other things as well before you're going to be putting your name on the pleading and filing it with the court. So there's a bunch of things that need to get done, and get done in rapid order.
But if you file one claim where in good faith you can file
one of the counts legitimately has a motion to dismiss, it would toll the entire time for filing the answer to the complaint, yes. Yep. Oh yeah, well listen, I call you up and I say, listen, I need 30, listen, I gotta get rid of that, I do that too much. I need 30 days, can you give me an extension of 30 days to file an answer? As for most of the times, that's professional courtesy, we're gonna give each other, even though it's gonna delay the case a little bit, but that's just understood. You say, no, I won't. Now listen, I can get 30 days, I can get 30 days, I can get more than 30 days for filing a motion to dismiss. Or I can go in and ask the court, can I get a 30-day extension to file a response because I've just been retained to have to investigate the matter consistent with Rule 11. I can get it either way. If I don't feel like asking the court, I'll file a motion, I'll look at the count, I'll look at your counts, find something that's weaker than others, and I'll file a motion to dismiss, and now I'll get 60 days. And now you'll have to file a response to the motion to dismiss. And so, yes, and I might do it, just especially under those circumstances. I asked you for an extension, you wouldn't give me what would normally we would extend to one another as courtesy. I'm going to take a shot at 5 and 6 then, and I'll see if those counts are as weaker than I might think. If the judge agrees with me, off we go. So, and that's the important thing I think about the rules as well, is especially as you guys begin to practice, it's even more important to know the rules well and where the play is within them, because people will try to push you around and try to get you to agree to things that they wouldn't expect more seasoned attorneys do. And the other thing, unfortunately, is that you guys will tend to do things at times that more seasoned attorneys just simply wouldn't do. Like, well, I won't give you the extension. Well, I'm going to, as a practical matter, I'm going to get it. So that's akin to giving me the sleeves off your vest. You have no need for what I'm asking you for, and it makes no difference because I can do better than this. But why burn a bridge? Because professionally, there'll come a day where you have that brief that's due on the Monday following the weekend, and you don't want to work all weekend either. So, can I get the week so I can go watch my kids at the Little League games over the weekend? And when you told me no, don't actually, you shouldn't expect me to extend the courtesy on the back end. I actually might, because I'd rather be, I'll give it to you, but I'm going to be petty about it, say you didn't give it to me. But I might or might not give it to you. It depends on our level of animosity at that point. And there's no reason for that, because you shouldn't become personally, I don't believe in passionless advocacy, but it doesn't have to become personal between us, right? The things we do professionally that don't hurt our clients' cases, that reasonably we should do in the practice of law. Relatively short extensions of period of time for legitimate reasons is one, because we all will need that request at times. So you got to be careful. Questions? The motion to dismiss is a good motion, used a lot. You should be used even probably more to some extent. I've told you before, I think insufficient service of process is a tough one to argue. If you're there to argue the motion, most judges don't really care that much about it, that they left it with your neighbor and you still somehow have it. Because what they're going to do is that's another easily curable one. They're going to send someone out there to reserve you. Some people will do it, and it's worth, if you think there's a reason for it, like, well, the statute of limitations has run in the meanwhile, maybe we can argue that they weren't served within the statute, and I've got a potentially dispositive motion. That's one thing. If we've got a year still to serve you and you're telling me you weren't served properly, well, I'm going to fix that within a year. That's not going to be incurable. If in raising certain issues, moving to dismiss, the court actually, you file affidavits, you file additional material outside the face of the complaint, that can actually convert a motion to dismiss to one for summary judgment. And the case could be over, the whole case could be over either by way of a motion to dismiss, a motion for summary judgment, very, very quickly. So you want to be careful how the court is actually treating that motion as well. Sometimes, some defendants' attorneys will file a motion to dismiss in the alternative for summary judgment, and you better have some information to combat that, or this case could be over before you even get a chance to step to the plate. One of the ways we do that is by saying discovery will prove that there are issues that would create those material facts in dispute. Franks versus GMC Truck Center. And we have AU, doctors, and Equifax to discuss. Franks versus GMC Truck Center is, I think, an interesting case. And the district court granted a preliminary injunction in favor of Frank's GMC Truck Center, compelling GM to continue to supply heavy-duty truck parts and to process warranty claims on heavy-duty trucks. Under Rule 65, they then have an argument about it and the like, and there's some additional issues that I want to discuss with respect to the granted injunction. But I want to go back to some of the things we talked about early on in Civ Pro. It says, following removal from state court, the U.S. Court for the District of New Jersey issued the injunction. What allows a case to be removed from state court to federal court? Like, why was this case removed? Both under the law, why was it removed, and why do you think logically it was removed from state court to federal court? Go ahead.
For diversity purposes.
What's that mean, diversity? So the case can be removed from state court to federal court on the basis of diversity?
On the basis that the plaintiff and defendant are from different states.
Yep.
And the claim is likely to be at least $75,000.
Yes. Reasonably likely to exceed $75,000. Where's the plaintiff from?
New Jersey.
Okay. And where's the defendant from?
Michigan.
Okay. And so why do you think Frank's entered in the state court of New Jersey his request for injunctive relief?
He doesn't want to have to go to Michigan.
Well, he doesn't want to have to go to Michigan, but he could have also entered in federal court in New Jersey. Why do you think he didn't?
Maybe it's some sort of favorable court, state court.
Yeah, right. If one were to try and make an assessment as to where the individual is probably more likely to be favored, it's oftentimes in the state court close to where the business may be, where he employs people and the like. You know, if we were to have a case around here, what our choices would be, well, we could go to Essex Superior, either in Lawrence or Salem, or we could file the action down in Federal District Court in Boston. And especially, say, we're representing Commonwealth Motors over here from Lawrence. That's not a bad case to take to Superior Court here. Everyone, Essex County is a relatively small environment where people know each other. And he might, maybe he not, some local plaintiffs wouldn't be benefited by being in their home forum. But that might be a place where the Superior Court is more likely to look after the little person. And for right or wrong, and I think it tends to be more correct, there is a school of thought that the federal courts favor large national businesses, and that may be why GM wants it in federal district court. It may also be their first of multiple moves here. I need to get it to federal court in order then to potentially transfer it out to Detroit. Because I cannot transfer a case from state court to courts of a different state. And so it may be just the first of many checkers moves that they intend to do. But they removed it on the basis of removal jurisdiction. The other thing to remember about removal jurisdiction on the premise of diversity is the defendant can't be from the jurisdiction where the case has been entered. So if Franks enters against GM in state court in Michigan, GM doesn't have a right to remove. GM has the right to remove here because he's entered in Frank, the plaintiff's home forum. GM's not from there. They can remove on the basis of diversity jurisdiction. Okay? So they're removed, off to federal court we go, and at this point, the federal court issues an order enjoining GM well, the order enjoining GM from what? What is GM supposed to do? What does Frank want them to do?
Franks want them to continue to supply the heavy-duty trucks and to be able to service, so that Franks can be able to service warranties on those trucks.
Continue to supply the trucks, continue to supply the parts for these trucks, but for other trucks, and to honor our warranty business. Sounds like a order requiring General Motors to do an awful lot of work here, no? I mean, because for whatever reason, they've chosen to get out of the truck business,
Well, they were teamed up with Volvo.
so they're gonna
Yeah.
have Volvos instead. And so now the district court says that Frank's will be irreparably injured if they lose this business. What injury will Frank suffer if they lose this business?
Lost profits.
Lost profits, right? The money, right? Well, if it's just money though, how does that get past the no adequate remedy in law and the irreparable injury nature of it? If you're telling us that you're losing money, profits, as a result of this, well, let's put a dollar value figure on it, and we'll give you, GM certainly can, at this point in time, could write to the checks, and we'll move on from there. Is that really, do they really have irreparable injuries as the court would oftentimes see it? And GM has another argument about the failure of the order here. What's the other argument? Not just that they're not irreparably injured. What else didn't happen that should have happened in this case? Yeah, they didn't post the bond under Rule 65C. And let's talk a little bit about the bond, because we don't oftentimes see that issue, but it is an issue, and Rule 65 does require it. It says that the district court failed to require the posting of a bond as mandated by FRCP 65. And then they say, because of that, we find that the injunction was improvidently granted. What's the bond for? And who, first of all, who posts it?
The moving party.
The moving party, the party seeking the party for whom the injunction is granted, must post a bond under Rule 65. And what is the bond supposed to be there for?
Well, that's to make sure that just in case that the injunction was issued wrongfully, that there wasn't a full investigation of the facts. If the other party was wrong, that there was sufficient, well, there was that security there to be able to pay or provide remuneration to the other defendant.
To the party against whom the injunction is granted, right? Because if GM has to comply with this order, this is an enormously expensive order for GM to comply with, right? We're going to still have to manufacture product and equipment, get it to you, and then keep an administrative staff there available to process a lot of this information. I mean, this is quite a bit of money. And in the event that GM is successful on appeal and showing that the injunction is improper, the bond is supposed to compensate GM for whatever losses it suffers as a result of the injunction being improvidently granted. And the court didn't even have a hearing with respect to the bond and how much would be sufficient in this case. And that may well be fatal, because it would appear to me that this is one where GM may well have to put out large sums of money to try and comply with the order here. Because they want them to provide parts and the warranty support on an ongoing basis. Is Frank's claim really simply a money claim? At the end of the day, he's losing money. Losing anything other than that? Because if he's not, it's really not an equitable remedy, is it? Go ahead.
Well, it said that it was going to take him out of that certain market if he didn't get those parts, which I found it a little harsh on the court to say, you know, we can still tag a money price on that too. Basically anything. His lost business was dollar amounts in their eyes, but I guess depending on what type of business, if this wasn't particularly a car business or something, maybe especially, you know, maybe it would have been different, but there should be about, you shouldn't just be able to tag dollar signs, I guess, on all of it. Or maybe you should, I don't know, I just thought that was.
Well, why not, right? Business is about making money. And but this is the problem in any business dispute if you're looking for injunctive relief. If at the end of the day, if all you're supposed to be doing is making money, for the most part, and now you're saying you're losing money, it's no injunctive relief. Even if we put the business out of business completely, we can value the loss of the entirety of the business. People sell businesses all the time. We have disputes concerning under what circumstances should be transferred and who gets what. We value them. even if it means the loss of virtually the entirety of the business. It's still money. There's nothing else involved in the running of the business. I mean, the feel-good nature of the family business. How long have you been doing business with GM? It was decades.
33 years.
What about business's goodwill? That doesn't count either. At the end of the day, Frank's losing money.
You could value goodwill as could also.
We could value goodwill as well.
Oh, yeah.
So, but then this would almost start to argue that in a business context, it's always really more often than not about the loss of money, loss of profits, revenues. That almost seems to argue against injunctive relief in any business dispute, for the most part. When the claim is we're losing revenues or profits as a result of it.
Well, if it is, for example, I could see a situation where, if it's not a situation like this, but if it's something that involves, let's say, patents, rights like
True.
that, then I think those are things that are much harder to value, and you could suffer really irreparable damage really quickly.
And that's a fair argument as well, as when we can't properly value the monetary loss, you can argue about the greater the likelihood of irreparable injury. If you can value, you can put a dollar value on it, then it's money, and maybe we shouldn't have an injunction at all. And here, if we can put a dollar value on it, then put a dollar value on it, you don't get an injunction. And as well, the problem is, as the footnote 7 makes clear, and I think the rest of the decision in B makes clear, GM is going to be out quite a bit of money if they have to comply with the terms of this order. Now, that requires or almost mandates posting of a bond. And so the posting of the bond becomes a second-tier argument against the issuance of the injunction, by the way, as well. Right? I'm going to argue against the injunction, but I'm also going to have an argument ready that if the court is inclined to grant the injunction, that I need a bond of X times 10 squared. Right? I want a huge bond because this is what's going to follow, and then I've got two chances of winning. Maybe the court won't issue the injunction, and B, if they do, they'll require such a significant bond that maybe the defendant won't be able to post the bond, or maybe the plaintiff won't be able to post a bond. And if they can't post a bond, then the injunction can't issue. And I oftentimes do say plaintiff can't post the bond, and the defendant is the person against whom the injunction is ordered. But that's not technically correct. Anyone who has a legal claim, either by way of the initial complaint or counterclaim, can move for injunctive relief. So as long as there is a complaint, as long as there's a legal injury, either the plaintiff by way of the initial complaint or the defendant in counterclaim can seek injunctive relief under the setting. But you have to have a claim. You can't just sort of file a motion. Sometimes I've seen that in the past. People say, well, just file a motion for injunction. You've got to have a legal injury established by way of a complaint or counterclaim, and on that basis, then the case can move forward and one can seek a injunctive relief. Frank can't show irreparable injury because he's got a money claim. Because the injury is pretty significant.
Well, yeah.
No?
It is. I mean, he's going to, that'll probably tie up a few $1 million of his own business.
And that's right too. This is not a small claim
No.
for him either. Sizable amount. But at the end of the day, it's money.
That's right.
And if it's money, that's really not immediate irreparable injury, and it certainly isn't the no adequate remedy in law that we use in the test as well. Sam, go ahead.
Maybe Frank just bought this term to probably push GM to pay.
Well, what's amazing, if you think about it, is it's a pretty significant order that he's able to establish from the district court originally.
Yeah.
It does make you wonder how he was able to get that order, because stay in a business the defendant no longer wants to be in, that they're found not profitable.
No, they're staying in the business, it's just not,
Yeah,
you're just not a dealer. I mean, they are continuing to produce parts, they're going to this joint venture.
Well, but it's going to be with Volvo instead.
But it's going to be with Volvo instead, but they're continuing to, because they're going to have to continue to produce the parts for the trucks. The federal law says you got to maintain parts production for 10 years past the anyway.
I think France.
But it's the warranty business that they have no.
Well, but they're legally bound to honor the warranties of the trucks that have been sold. The question is whether or not Frank's is going to be an authorized warranty dealer, if you will. That is, can they go to Frank's for the warranty? So it's not a question that they're going to have to stay in a business they're trying to bail out of just because of Frank's.
No, well, look at footnote 7, John. It's a little broader than I think the way you're describing it. GM will have to obtain the parts from someone and get them to Frank's. And then it will have to expend to set up and administer a warranty service program because Volvo had agreed to assume responsibility for the entire warranty service. If GM has to do it now and not Volvo GM, then that's an added expense that they do not want to engage in. They had, seems to me, I would say sublet all of that business out to Volvo.
If GM had decided that Frank's would be one of the authorized dealers, we wouldn't have this discussion. It was that he was not selected as one of the.
I don't think they were selling that. I don't think they were doing the selecting anymore. Read the second part of that paragraph. Frank's GMC argues that any damages incurred by GM are its own making. To some extent, I think they are. Because GM has made the choice to dismantle its warranty support program and sell off or transfer its parts inventory. So GM's not going to have parts for the vehicles any longer. They're delegating all of this to Volvo. And so to some extent, requiring GM to buy parts, to have the parts, to ship them to GM, and then honor the warranty, that's telling GM, you got to be in a business that GM has decided we don't want to be in anymore. Go ahead.
What contractual obligation does does GMC truck have to Frank's? I'm kind of mystified as to why there is nothing mentioned about the contract, which really impacts the the likelihood of success in the merits argument. From what I understand, not reading the case, this event took place in Volvo. GMC truck negotiated this with Volvo. Part of the agreement with them to sell off this division was that Volvo would assume through their network their ability to maintain these trucks, not through the networks that General Motors had established. And so where's the underlying contract? What contractual basis does General Motors have to Frank's? I mean, is it a perpetual contract? I mean, where did they come up with the idea that they were going to prevail in the merits?
It's a franchise.
Yeah, but it's not a perpetual franchise, is it?
No,
I mean, where's the franchise?
I think you're arguing, well, how is it different than Dairy Mart?
Exactly.
It's about, right?
Right. There had to be a way out for GMC, just like there must be a way out for Frank's. At some point, they must say,
It's
okay,
not profitable
we're not
business,
going
we're
to
not
have a
going to do it.
relationship anymore. It's done. I mean, I can't imagine GMC trucks selling off a division of their business without having a way out of their franchises.
The way this probably works, if I was Frank sitting there, I would watch GM, I would watch my business dwindling, and I would go, holy Moses, I can't talk to these guys. These guys don't want to talk to me. They're too busy. You know what? I'm going to haul them into court. I think that's what happened.
Well, I don't think there's any contractual obligation for GM to continue to manufacture the parts themselves. And I think if it was, we would see mention of it in the case. And that's the problem. John points out, well, and there are other federal statutory laws that require certain things of the manufacturers and the dealers that none of the case doesn't make reference to any of that with respect to the availability of both parts and termination of dealerships. But you would think if there was a stronger contract requiring certain shipment over for an extended period of time, we would see that. None of which it seems to indicate in the case Frank's has a legal obligation that he can insist that GM on.
I mean, just look at what they did when the bust hit Detroit. He just went in and decided to get rid of all these franchises.
Right. They must have within their agreements the ability to terminate the franchise. And they do. As we saw, it's actually happened within the last 24 months as well.
Which would strike right to the heart of the likelihood of success in the merits.
Correct. Correct. Let's talk about Aoud versus Mobil Oil Corporation. Well, okay, why are you laughing? We've done this case before. One time we did it, and his nephew was actually sitting in class with us. Why were you laughing?
Well, I mean, apparently the guy, he's already in a franchise. He's already operating one franchise. He's aware of what is going on, and he just tries to do an end around, you know. And if you're going to do an end around, I think you want to choose who you're going to be doing an end around against.
And you don't pick up Mobile Oil?
No, you can't do end around against none of these big giant oil companies. It just doesn't work.
I don't think it was the initial end around didn't really get me, because at first it was like, okay, like he's trying to creatively get around this. But then it became, like, well, then this was a fraud. Then he didn't tell them about this. Like, as you kept reading the case, it kept getting, like, more and more unbelievable. Like, are you kidding me? Like, he really thinks they're gonna, like, grant him this end around now, when he's just, like, basically tried to treat them like fools? I mean, you can't do that.
Well, let me ask you about the end around, because, and I recognize the significance of who he's playing against. But geez, the rule seems kind of silly, doesn't it? But it's their rule. I mean, I'm running a really good franchise. I know how to run it. I can run another one, and it's not that far from my existing one. I can make both of us money. But Mobile has the right to make their own rules.
Yeah, and Mobile probably is looking at some other strategy for their franchises, which he's not even aware of. Maybe they're planning all kinds of consolidations, getting rid of, relocate. That's the way they do it. You know?
So, your sympathies are not with him.
No.
I'm wondering, you as his attorney, what steps you took, because I'm looking at, let me actually give you a little background on the judge who wrote the decision as well. Judge Celia, as you can see from the choice of a lot of the language he uses, he loves to write, he writes very well. And in his latter years, his sight started going. So in the First Circuit, there's a requirement, and there are local rules, and this is why I wanted you to make sure you know it. There are local rules in the First Circuit that when you file a brief in federal court, you have to also file it. This was before. Now you actually file it all electronically anyway. You would have to file the brief on a CD as well, so that the print could be enlarged for anyone to read it, specifically Judge Celia, in the early days, because his site was going in 12-point print or whatever point print we would be using just simply wasn't large enough. My point to you is this. You know, I always quote the Federal Rules of Evidence to you, the Federal Rules of Civil Procedure, the Federal Rules of Evidence as well. The Federal Rules of Civil Procedure, in any given federal court, both at the district court and at the appellate level, there are also what's known as local rules of court, which dictate how specific things must be done in that court. For instance, one of the rules you would find in the appellate procedure is that your page, the size of your page, the size of your brief, both by pages and by font size, there are specific requirements that if you don't follow those rules, they're throwing your papers back to you. And it's not going to give you if you're late, then you're out. So when I went to law school, they didn't tell us anything about local rules, and when we were sworn into federal court, Judge Wolf asked, who knows here that there are local rules in the federal court? We all raised our hand, we didn't know. But since he asked us that way, we were smart enough to raise our hands. What I want you to know, because you can get admitted, once you're admitted in Massachusetts, you can then seek admission in federal district court. It's done by way of paperwork. But if you're going to practice in federal court, you need to know how to file papers electronically. It's really quite simple. There's a tutorial right online if you want to go and figure it out now. I think it's ECD after you Google that, electronic court district filing. I don't know what the hell it is. But you can go to the First Circuit, Mass, they'll give you a little walkthrough, and it's relatively simple if you, and most of you look like you have far more technological abilities than me. And I can do it, so you can do it. And you must file papers electronically, but you must know what the local rules are. And the local rules govern everything. If you want to file a motion with respect to pertaining to discovery, The rules require that you meet and discuss the discovery issue before ever filing a motion and a brief with the court. And so there's a lot of things contained within there that if you don't follow them, they're gonna kick it back on you. It's that simple. And so recognize that once you do start to think about practicing. And so that's Judge Sellier, and he was always known to write as, as he writes here, which I think is interesting, and obviously we could learn a lot of new words working with Judge Sellier. But I wonder about this fake P&S and how deadly you think that is for the plaintiff's case, because you attach that to the complaint, right? Because that makes you look pretty bad, doesn't it?
That was like
A whole new level of
well,
bad.
because you're basing your whole claim that you purchased this in good faith, and so if you file a fake P&S, I think it kind of defeats your whole. Like, were you really trying to fool us from the get-go, or did you think we were that retarded?
But now you're trying to fool the court too, right? You. And that's what I wonder. How do you protect against something like this? He gives me the P&S. I look at it. It looks okay to me. I think it's a good, strong document. I attach it to the complaint. Because now you're standing next to this guy in court at some point.
What's the
This is
penalty?
not going to, and I'll tell you, before this guy, if you were arguing an appeal, this is going to get really very ugly.
What's the penalty for your client perpetrating a fraud on you in the court?
Well, what do you think the penalty is here? Why is it in footnote 2? Because I'll be honest with you, once I read footnote 2, I said, I think I know where this story ends. And don't you? Because that seemed to be what I heard. He laughed when he even brought up the name of the case. This is over early, isn't it? And that's what I'm wondering, is it over early especially because of what he did and how he got caught? So then my question is, so then how do we make sure that clients don't fool us and hurt themselves in the same process? Because I'm sure the attorney, at least initially, had no idea his client was so corrupt. But he is, right? Or did you know when he was telling me, well, I was trying to pull a little one over on mobile and, what the heck? I could do a good job and I could run both franchises. I mean, because if he told you even part of the truth to begin with, he wasn't completely honest ever, was he?
I don't think he was very honest with his attorney.
Well, his attorney or the client? You just said attorney, right?
Yes, attorney too, I think.
Well, really? Or was he or she swept up? I mean, wait. It sounded to me before when we've had a similar discussion, you guys will represent clients who will be less than 100% blame-free or incredibly meritorious. Right? We'll take some of the weaker ones, because they deserve their day in court too, right? Both from a plaintiff and defendant. This is what you've said, isn't it? I'm not trying to mischaracterize it. And I'm wondering how you avoid something like this, because he was doing himself a disservice. He dealt himself a fatal blow when he gives you this dummy P&S, you attach it to the complaint, and then once I read the footnote, I don't need to read the rest of the case. He's going to lose. The question is why. The question is, what reasons are they going to tell us now? But he's DOA.
Oh, wouldn't you investigate the purchase and sales agreement and look at it and ask your client, well, who drew it? Did an attorney draw it? And also look for some consideration. I mean, most legitimate business purchase and sales agreement, unless it's family, have some kind of a deposit, and then wouldn't you look for a deposit and look for proof of deposit? At least do
How far
it
do you have to go, I wonder?
I think what you have to do is a Rule 11 diligent search, and I think it,
documents. I got documents. My guess is he could give us some type of phony canceled check. I mean, right? And I'm just, how far do we have to go to protect ourselves against something like this? Or, Professor, this guy's 1 in 100. You can't necessarily protect your back flank against someone like this. Is that true? Or is this what we have to be worried about?
You have to at least make an effort. I mean, at least if you, let's say he was really slick and he had all these phony checks and stuff. At least you could say, well, Your Honor, this is, look, he he showed me this check, he showed me this, at least you can cover yourself by doing a diligent investigation, and if he's a real good con man and he gets you, at least you've done your search.
All right, now that I think we've determined that we can be fooled, all right, how do we withdraw from this case? Do we need the court's permission if we decide to fire ourselves?
I think as soon as you find out that
That you've been used.
oh yeah, you just.
I mean, as soon as I found
Well, you
out-
need permission to withdraw unless you've got successor counsel, and no one's gonna sign in on something like this. No one's gonna sign in on something like this. Well, let me ask you that. He calls you, he says, listen, I'm having problems with my first attorney. I can be down in 10,000 cash this afternoon if you can file an appearance. In?
Done.
You're in. You were just telling me you had to get out quickly because he lied to you, but now you'll be the second attorney if he's got 10 grand
Because
in
he liked
cash.
the first part of your
He hasn't lied to me
sentence.
yet.
What?
He hasn't lied to me yet. Okay?
And he liked the first part of your
Now
sentence.
that,
But you have better reason to think he's going to lie to you than she had when she filed the complaint with the P&S.
oh, he's not guilty until he offends me. No, what
I said that.
I'd sit him down. No, I mean, he needs representation. I'd sit him down and say, look, you blew it with your last counsel, and you can't be purporting, documents that don't exist. You can't be asking me to represent documents before the court that are fraudulent. Now, if you
Hasn't he
promise
dealt
me-
himself a fatal blow anyway? So what is it you can even do for him here, other
Well, I
than
think that- I don't think
attach
you
your
can.
reputation to his and cash the check?
I get cash the check. I don't think the case has any merit, but I will, I'll sit and talk to him for.
Wait a minute.
I
He
would
says
say-
no merit, but you'll be signing the pleading once the check clears.
No. Once I sat down and looked at all the filings, and I would advise him based on what I know about the case now. I wouldn't know that going in if he just picked up the phone and called me and I didn't know anything about the case.
Well, but he
It's
told
like
you
my
I'm
cousin.
having problems with my earlier attorney.
Yeah, and not knowing anything about the case, I would.
Okay,
I
so
would-
now he tells you about it, tells you what's gone wrong, there was a mistake, she attached the wrong P&S to it, I don't know what the hell's her problem.
Yeah, if I could believe all that, I would say, okay.
Well, you have to
Now-
believe it, or it just has to make a credible case.
Well, or even if he told me that it was fraudulent, if he even told me it was fraudulent and he made a mistake and he's sorry and he won't do it again, okay, now we look at the merits of the case. And now we're gonna conduct an analysis
Well,
of what they.
what about this? It says he swears that they approved the transfer. As God is my judge, they told me face to face they approved the transfer. Is that good enough for you?
Did we never depose
She
that?
says no, she says he's a liar.
We never deposed, did we ever depose that witness for?
Not, well, listen,
ExxonMobil?
you're not getting very far, because attached to the complaint is the bogus document that sort of cuts you off at the knees. Right? So.
Yeah, but we'll resolve that with the court. We can resolve that with the court. We'll file the correct, accurate purchase and sale.
Can't you
agreement.
resolve it with the court? That's what I'm
We won't change the
wondering.
numbers, we won't fudge the numbers. We'll put the
Is
right
this
numbers.
recoverable?
But then the next day, he prepares a new one and backdates it, and then
Yeah,
signs
that was a
it.
mistake.
Like,
Yeah, but he's not gonna do that with us, because you and I are
What,
gonna represent.
no,
him
but this is
and
my
we're
problem,
not gonna
Princess.
let
Why
that
do you
happen.
think he's not gonna do it with you? Because this is the type of person you now have aligned your reputation with. What makes you think he won't do it to you?
He could.
He's likely to, isn't he? No, you got, and listen, we can't always pick our clients, okay? I know that. I gotta give you examples where I didn't get to pick them, especially when you're in a firm. You have choices. If you either take the client that they give you, or you can walk out the door and then not pay your bills and not have a job or whatever. But you don't always have the choice of who you get to pick. But there are some that should be sort of ringing bells off when you see it. And isn't this one of them? Is that I'm not sure I can. Well, I'm not sure. I can never believe this guy. Can I? Can you?
No, I mean, this is tough.
He tells you he's trying to pull a slight con on mobile. Now I was okay with that because I thought the rule's kind of foolish. And so maybe if the rule's foolish and someone says, yeah, I've got you an exception or you can convince me of that, okay. But now he's dummying up documents. So every document, everything he ever gives me, I can't truly feel comfortable that that's legitimate. Everything he ever says to me, I start out believing it's a lie, don't I? You know when I get worried these days? It's when I ask people questions and I never get the answer, no, that's not true. It's, oh, let me explain it. You know, I say, actually, I've had one of these recently say, you know, one of these times I just want them to say, no, that's not true. And honestly, about like 6 to 8 things I said, go, you don't believe what this is. They said, oh, let me explain what that happened then. Let me explain. Can't you just say no? Once just say, no, that didn't happen. And so even with that one, who's I think being more honest than most, you start to say, I'm getting a little uncomfortable here because there's always a story instead of a simple denial of something. Here, what we've got going in now, we know that he's not truthful, he's not honest. He's not honest with Mobile, he hasn't been honest with you, and he sort of sucked you into this mess. Because the next time you go back into court, the judge is going to remember, oh, you were the guy with that phony evidence that you tried to push down my throat. You are, aren't you? Because I worry about that. I'd rather be seen as the good guy than the bad guy. I'd rather be seen as honest than potentially dishonest. And who we associate ourselves with is, right? Didn't your mother tell you that? And that's right.
Lie down with dogs, wake up with fleas.
That's right.
No, I don't buy it.
The problem is, and I'm not, you know, and by the way, I've got a fair amount of emails on your scathing attack on attorneys. You should know. The problem is, a lot of who we represent are dogs, aren't they?
Yeah, but I don't buy that guilt by association argument. You know, I mean, I think as attorneys, we're gonna represent guilty people. We're gonna represent people that don't have the same honor with truth and justice in the American way as we do. And we.
Whoa, wait a minute. What are you saying? I'm gonna make you go sit with him in a minute. How is that such a blanket assertion? I'd like to think that the people I represent are truth, justice, in the American way. They still believe in the ideals that we believe in. I'm just saying, in our business, I think you can find a lot of people who don't. But aren't most people looking for you to actually bring them some direction and help and believe in sort of the same things that we do? Or I'm not prepared to say they all are dogs.
Which feeds right into my argument that Ahud needs a savior. He needs a champion. He needs somebody to set an example for him.
But doesn't he need someone else? No, I mean, that's all I think you have to ask, because, first of all, I don't think this case can be saved. I think he has dealt himself a fatal blow looking at it, and you have to understand how quickly that can happen. Right? I always think that first we've got to convince the judge that we're on the right side of things, and they should go look for reasons why to support our case. I think that's, by the way, lawyers and judges make their decisions anyway. Is, okay, listen, I want the plaintiff to be able to win here. Does the law support that? Or go find me law that supports it. Right? I think that's the way it works. Because you guys have done enough research, haven't you? The law isn't black or white. It's gray. And so I've got some law that says plaintiff wins. I've got some law that says defendant wins. Who do I think is right here? How would justice look at this? I do think that's the way you work, isn't it? You represent a client. You're going to go find law that supports your client's position. You're going to advance that as the law. But it's not the law, because she's got law that goes the other way. Well, we don't think that judges might work the same way? I need you to be sympathetic and empathetic and care that my client deserves justice. That's my job to get you there. And then your job is to take the cases I give you and say, that's why I win. This guy loses, and he's going to lose, and we're going to find a way to make sure he loses. Go ahead.
So I think we all agree that he's not credible. I mean, based on his actions,
No, he's
right?
worse than not credible. No, really, right? He's dishonest. He's worse than not credible, isn't he, Dan?
Yes.
Okay, so go ahead.
But if he had legally a meritorious case, or more meritorious, then would it be the same? Does he lose anyway because of the credibility? Is the credibility the thing that kills him?
Well, isn't it because you now can't believe a word he says about anything, can you?
I did not have sex with that woman, and now Chris Matthews has him president of the world. just because he files a bogus P&S statement doesn't shoot his credibility forever.
For this case, it's
I'll
pretty
say
good.
that, I'll agree that it doesn't make a real strong case for him, but,
Wait, but you're using an illustration you couldn't possibly agree with to make the point that you might be a decent person. You've become a lawyer, John. The lawyers you hate, by the way, it would seem to me.
yes. No, they're both flea-written curves.
Okay, let's talk about why he's now going to lose. Well, what about this, by the way? You missed stating what the law is as well, right? Plaintiff tries to convince us that Massachusetts law does not allow courts to enjoin a trespass. Well, that's just crap too, isn't it? That's what they say here. It is indisputable that the Commonwealth, as elsewhere, continuing trespass on real property, such as the district court supportably found that a use was perpetrated, can properly be enjoined.
Who advanced that argument? That wasn't.
Who was this lawyer?
That wasn't Owen, because he's not pro se.
That's a sleazeball lawyer that you are. All right? No, because that's the thing. Now, and this is my point. Now you're just getting sucked in with this. Now, by the way, they're only using the C site. You would think they should be able to do better if it's so unmistakably the law in Massachusetts, but they don't. But I think it is unmistakably the law. I just think they should have found a better site. And that's the worry is now, because that's saying, they say plaintiff, but they say, really say plaintiff's lawyer. Plaintiff's lawyer tries to tell us this. See, and this is what I worry for you, is that innocent or not, trusting or even questioning, you still get tarred with the same brush. It is guilt by association, isn't it? You know, mob lawyers. Somehow those mob lawyers are not as trustworthy or as honest as others. Well, now you're sleazeballs lawyers. He talks about a waiver, but let's talk about the lack of hearing. And this is why this should, and we talked about, we looked at this before. The district court granted the contested injunction without convening an evidentiary hearing or a hearing oral argument. Normally, we would look askance at such a praxis. As a general rule, where issues of fact are disputed, an evidentiary hearing is a highly desirable prelude, if not a necessary concomitant, to the granting of an interlocutory injunction. But because we don't give a rat's ass about this guy, we're going to say it's okay, right?
Well, didn't they do that with delayed findings too?
And the delayed findings as well, right? He's killed himself.
That just jurisdictional prerequisite to the posting of the bond, is that the local rule you were talking about?
No, 65C is within the actual federal rules of civil procedure, is the requirement of posting the bond. The local rules would dictate, I think that dictate how that hearing may have to be held, but 65C is what governs the bond.
Okay, so I'm confused. We're in the same federal district, second, right?
Yeah, first.
I thought we were in the second. Oh, no, that's the
No,
report.
first is
Okay.
this circuit.
All right, so in the year 1990, and in one case, the court tells us that
Must be a hearing of substance.
there must be a bond.
Oh,
Amount
yes.
of bond required filed by the party obtaining under 65C. And then in this case, am I wrong?
No.
Posting a bond is not jurisdictional prerequisite to validity of the preliminary injunction. What's up with that?
They don't care about this guy. They're going to twist the law, and they don't care about him.
All the reason why we need to represent him.
I understand and think it's admirable that you want to attach your reputation to his. I think it's also foolish. I think there are those clients that are not deserving of your representation. They can find someone else. I think a case like this, if you're looking at the decision, they're violating a bunch of law to get to the result they want. And most people don't care because he's a cheat and he's been shown to be dishonest. And that's the problem with it. I'm not saying, well, I'm not sure it isn't right. because he tried to lie to Mobile, it appears now, because now we don't believe anything he says. He dummied up the documents. He used you in an effort to try and persuade the court of his phony position. And once discovered, the court decides we're going to brew his case quickly out of here. Well, isn't that the price of poker for lying to the court? And I'm not saying that, you know, like you said, and the rule, by the way, in the bond is very, in the case law is very odd and twisted on it. The rule actually, and we're going to look at bonds as well as we go forward, the rule says the bond must be posted. I mean, the rule couldn't be clearer. That's not the way they interpret must post a bond. It's the court's interpretation of what the rule says is at times opposite to what the rule clearly mandates. And I think there's a couple other issues with the bond here, and that is why the case is here, as Francis points it out. Another very standard rule: if you want something, you've got to ask the district court for it. And they made no request about the bond here. And if you haven't asked for the bond, don't complain later on that it wasn't filed. And so I think that's one of the big principles they're using on using to avoid that issue. It says, after all, we have regularly declined to consider points which were not seasonably advanced below. And I think it's based more on appellant didn't raise the matter below, they rejecting that assignment of error as untimely. But how they make the first part of that sentence that Francis points out, because posting of a bond is not a jurisdictional prerequisite to the validity of a preliminary injunction. Well, the rule seems to indicate it does, and so does the case we just looked at would seem to indicate it does. They go the other way with it though, and they say they don't see it as a significant problem. And they also cured that problem if you look at 8, and again, going out of their way to try and avoid, to try and say they simply don't care about the errors that were in this case. Mobile knew they needed a bond because after he filed this opening brief in this court, Mobile then goes down to the district court and says, hey, maybe you ought to post, amount, maybe you ought to fix the establishment of the bond and we'll post it for you. And so what Judge Nelson does at that point is set the bond at $60,000. Mobile publishes it like that and says, well, if there was an error, it's been cured. None of which is correct procedurally. It all should have been done long ago. So should Judge Nelson's findings under Rule 52, none of which at the end of the day really matter because they don't care about this cheat. And I think your job sometimes is making sure that your clients don't shoot themselves in the foot. And sometimes that means asking harder questions and pushing them further so that they understand how deadly certain things that in a business context people might just throw out as puffing, or that in other contexts people will say, well, I was mistaken, how some things can be fatal. And I guess what I'm trying to convey to you is, I think you oftentimes owe your client that additional level of either cynicism or scrutiny so that they understand that there's equally smart people on the other side that are going to be challenging this as well. Because some of our clients think that they're the smartest people in the room. And that's probably why they got into this problem in the first place. And the fact is, in a piece of litigation, that they're oftentimes by far not that, and everyone is paid to question a little further and dig a little deeper. And if I try a case, I go through a cross-examination with the client and our witnesses. I need them to know what they're likely to expect. We need to do that in the same instance with the clients early on. And that's not always an easy thing because we're trying to build trust with them. We want them to confide in us. We want them to have a good experience with us. And if you don't believe me, you don't trust me, well, probably not going to answer those in affirmatively, but I may be evidencing some signs of being dubious about what you told me. But that has to be done. There's a balance here. You know what part of the story just doesn't make sense? Why do you think they did this when the document shows this? Or what do you think they're gonna tell me when I call your employer and ask them this or that? Or what do you think they're gonna say as to why they terminated you? And it has nothing to do with sex discrimination or gender or bias or whatever. Well, they're gonna say, I frequently didn't show up for work and I did this. Well, to what extent, when, to what extent didn't you show up for work? When? And you've got to plumb that further so that you can work out some of those issues in advance and you know where it's coming from. And I think it's hard. Someone gives you a document. I really don't, he's making the same. I don't expect that people are going to go out of their way to phony up evidence to give you.
I think
But I've had that done in cases.
How do you know-
Attempted to do to us.
How do you know the first instance when you take that case? I mean, how do you know unless, I mean, this was a pretty simple transaction, but unless you talk to, I guess, the other party, but he backdated it too, so how do you know? It's between two people, so how are you gonna find out in the first instance? And that's the problem.
You don't always know. That's why you gotta make sure you gather everything as much as you can, because you don't always know. And I think some of it comes over time. How old are you? Do you mind me asking?
26.
Okay, how old are you?
25.
Okay, so I think I was your age when I became a lawyer. And people bring you stuff and you're much more trusting than just the way it is than as you get older. And I think now, and I'm still going to be wrong on occasion, but now you can just sort of tell a lot more than earlier. And I think that's especially why it's important for you, to you guys, for all of us though, as new lawyers, you got to take a step back. And I don't mean take a step back so that that you're not going to care about your cases, but you've got to be careful how you attach your name, because your name and reputation is attached to this. And I think this thing would be very difficult to uncover, perhaps. But, because I don't know, I mean, you give me a letter, you give me an email, I assume it's accurate. And there's nothing worse for the case than to find out that someone's given me stuff that isn't accurate, isn't legitimate, because now you look complicit in it.
I have a question. As his lawyer must have known during the discovery phase that contract existed.
Yep.
And the lawyer must know that's a death knell. That's a big game changer. And I am surprised this case hasn't made it through, because I would be telling him.
Well, it is interesting, you're right. This didn't just go through the district court. Now he's taking it to the appellate court,
Yes.
and he's spending some real money on this case. And I'm surprised that because to me, it seemed pretty clear once the fraud was uncovered.
That's it.
That's right, that's it. And again, you're not trying it against the Little Sisters of the Poor. You're trying against one of the largest corporations in the world, or in the country certainly at the time, and represented by firms that could clearly put enough resources into the case that the likelihood is this is just not.
That's going nowhere.
It's going nowhere. I don't disagree with that. Let's take a quick look at Doctors Associate versus Stewart. Franchisor filed petition to compel arbitration against franchisees. The district court ordered arbitration, issued a PI barring them from prosecuting their suit against franchisor in Illinois. Another franchisee case. And what's interesting about this is, again, the problem with the bond and the like. But I also thought this is an important case for you to start to look at and think about, because a lot of agreements these days, business agreements and otherwise, carry with them required arbitration provisions. But how do we get them to the table to arbitrate? Can we actually use the court process to force the arbitration? But we said that we would arbitrate it, and that would tend to mean not going to court to do that. So I thought this was an important case for you to look at, because there's a contract to arbitrate, there's contractual provisions with respect to personal jurisdiction and the like, and then they also talk to you about what the common law elements of fraud are, that a false representation was made as a statement of fact, that it was untrue and known to be untrue by the party making it, and that it was made to induce the other party to act, and the latter did act to their detriment. What we have in a lot of these situations is claims back and forth as to who committed the fraud. But the question then becomes, in this case, and this is why it's here, because this week is on bonds, that to what extent does the practice mirror what the rule requires with respect to the requirement that a bond actually be posted? And that's in the last part of this decision where it says, defendants in distress, the district court did not require a preliminary injunction bond. Again, we disagree. Now they quote Rule 65C here, and it says Rule 65C provides that no PI shall issue except upon the giving of a security by the applicant in such sum as the court deems proper. And so then the question becomes, because it's clear it's required, what does in such sum as the court deems proper? And the courts interpret that as meaning that they, the courts, have wide discretion to even require no bond, but only where there is no likelihood of any risk of loss to the party against whom the injunction is granted against. Go ahead.
No, I was going to make the same point in the last case, the Aoud case, that that clause says that the court was within its discretion to.
In such sum as the court deems just.
Yeah, I mean that's a lot of wiggle room. I was just trying to get to the summary of bond posting cases that they refer to confirm that. It would certainly seem that it's not the jurisdictional requirement if it's left to the discretion of the judge to determine the amount.
Well, the sum is left to the discretion of the judge. So a buck. But wouldn't even a buck indicate there has to be something? And here's the problem, though. Well, if it can be said as a buck, and it could, well, aren't we just arguing how many angels can dance on the head of the pin? If the court has the discretion to set it down to virtually nothing, then shouldn't it have the discretion to set to nothing? That's his argument, and that's the way they have interpreted it. That's the way the courts have interpreted their own power. The problem with that is there's some tension in them interpreting the extent of their own power. Because oftentimes, the requirement of the bond, especially if the argument, especially as it says here, if no one really advances that there's much risk of loss, then the court clearly is within the discretion to set either a low or no bond. That's why I think it's incumbent upon you guys to make the argument that if the injunction is granted, there is a risk of loss, serious monetary loss, and substantial to your clients against whom the injunction is granted. And if that argument's made, I'm not so sure the discretion is as vast as the court feels it is. If I can put forward a pretty solid showing that if the injunction's granted, I'm at risk of loss of, X, Y, and Z plus whatever, then I think the court is harder pressed to either waive the bond or issue a relatively low bond. In most PI cases, the bond is actually a pretty perfunctory matter. $50 bond, and it's just a posting of a check. What we have to do, what you have to do, I think, is make stronger arguments on the second tier of the opposition to the injunction, that not only doesn't the movement satisfy the five-part test, but if the court is inclined to grant it, then there needs to be a substantial bond for the following reasons. And cases can be won on the second half of the argument, because if the movement can't post the sufficient bond, then the injunction can't issue. The problem is, as you look here, and there's other cases that support this as well, the courts feel that they have discretion to even waive the bond in its entirety. But I think a careful reading limits that to where there's really no chance of any loss. And that case is those cases are somewhat rare where there's no chance of any loss. Questions on the case? I'll see you next time. Oh. we had a 93A count in there you saw for either business v. business context or business v. consumer or consumer v. business type of situation. And you know, if we're going to plead various federal rights that we might have, we might also, you know, almost always likely to plead some state actions in that complaint as well. What you're supposed to do when you plead matters in a complaint is look to try and really uncover the various legal theories that might justify relief for your client. And more often than not, you know, you have multiple counts, whether it's intentional infliction of emotional distress, negligence, false imprisonment, whatever it is, you have various counts in that complaint. Well, a motion to dismiss can be used to test and see whether some of those counts shouldn't survive the motion to dismiss. So if I'm facing 6 counts, then maybe what I might bring a motion to dismiss to combat various of those counts as to why they shouldn't survive a motion to dismiss. And that may seem to you like, well, why bother if the most of the counts are going to survive? Well, because depending on what counts survive, that's going to talk about also, to some extent, the scope of discovery, right? The scope of discovery is anything that's relevant or that which will lead to relevant information which isn't otherwise privileged. Well, if I throw out your false imprisonment and your kidnapping count, and all we've got left is a negligence count, well then your discovery should focus on that. And then ultimately what goes to trial should have to focus on those issues as well. So we're narrowing the scope of the plaintiff's both discovery and the action that they can try at trial. And it's not uncommon that when people plead in their complaint multiple counts, obviously some of them are weaker than others. And if they have failed to state a cause of action either factually or legally, I think it is your obligation to try and throw out those counts. For instance, it's not uncommon in Massachusetts to plead a 93A count if we've got a 93A claim that we can make with a straight face. Well, the problem with the 93A count is that from the defendant's perspective, losing on that count means I pay at least double damages plus attorney's fees. And so that gives the plaintiff real leverage if that count exists and is able to go to trial. Well, if I can knock that out because in a consumer v. business context, it has to be preceded by a 30-day demand, and you didn't make that 30-day demand letter, well, then that counts up. And I can move to dismiss it because you failed to follow the statutory prerequisites. And I do think that that's your job as the defendant's advocate to cut out the causes of action that are weaker, assuming not just weaker, but can't survive the motion to dismiss legally or factually, and go to court, go to trial on a narrower case against your client. And I also think from a strategic standpoint, if you're defending, anytime I can weaken the strength of the plaintiff's case and make them look more weak, and make them look like they've overreached in coming after me, even better, because now I'm going in, gaining ground, gaining momentum as we go forward when the court agrees with my legal position that counts 2, 6, and 8 should be gone. Of course, this still leaves 5 other counts in the complaint, any one of which will be enough to win. But the fact is that there are oftentimes, especially in a multiple count complaint, there may be some counts that won't survive, legitimately won't survive a motion to dismiss. Questions on motions to dismiss? When I call it the testing motion, the idea is that sometimes you look at a count and you look at a cause of action, or you look at the action itself as to where it's filed, and you think that there may be either procedural or substantive deficiencies with it. Why not test that? Why not test and see if you're accurate, and see if the judge agrees with you that some of these counts shouldn't survive? And if you are successful, you've narrowed the reach of the plaintiff's action. But
so could you, as kind of a matter of course, use a motion to dismiss to extend your time? Because doesn't it toll your time to answer?
it does. I don't know whether I'd do it as a matter of course, because remember, any document you file with the court is subject to Rule 11. But as long as you can make the argument with a straight face that there may be procedural or substantive deficiencies, then you should do it. But it does give you, from the other standpoint, filing the motion to dismiss allows you to, investigate the case fully, as Rule 11 requires, and to marshal the evidence so that you can either answer fully or file an answer and, in fact, a counterclaim against the other side. So I won't agree with as a matter of course, because I don't think you should just do things routinely. I think you need to think about whether it lies or not. But I think there's very few claims that are so clearly legally and factually established that oftentimes it doesn't. Oftentimes you can find a way to make use of a motion to dismiss. Let me put it this way. I think from my experience, I've probably seen it in about half the cases that I have. That sometimes they'll just file an answer if it's so clear and it's a relatively narrow complaint. Other times when you've got a number of counts, and all the counts are not as solid as each other, you will see someone take the chance to attorneys just simply wouldn't do. Like, well, I won't give you the extension. Well, I'm going to. It's a practical matter. I'm going to get it. So that's akin to giving me the sleeves off your vest. You have no need for what I'm asking you for, and it makes no difference because I can do better than this. But why burn a bridge? Because professionally, there'll come a day where you have that brief that's due on the Monday following the weekend, and you don't want to work all weekend either. So can I get the week so I can go watch my kids at the Little League games over the weekend? And when you told me no, don't actually, you shouldn't expect me to extend the courtesy on the back end. I actually might, because I'd rather be, I'll give it to you, but I'm going to be petty about it, say you didn't give it to me. But I might or might not give it to you. It depends on our level of animosity at that point. And there's no reason for that, because you shouldn't become personally, I mean, I don't believe in passionless advocacy, but it doesn't have to become personal between us, right? The things we do professionally that don't hurt our clients' cases, that reasonably we should do in the practice of law. Relatively short extensions of period of time for legitimate reasons is one, because we all will need that request at times. So you got to give. Questions? The motion to dismiss is a good motion, used a lot. You should be used even probably more to some extent. I've told you before, I think insufficient service of process is a tough one to argue. If you're there to argue the motion, most judges don't really care that much about it, that they left it with your neighbor and you still somehow have it. Because what they're going to do is that's another easily curable one. They're going to send someone out there to reserve you. Some people will do it, and it's worth, if you think there's a reason for it, like, well, the statute of limitations has run in the meanwhile, maybe we can argue that they weren't served within the statute, and I've got a potentially dispositive motion. That's one thing. If we got a year still to serve you and you're telling me you weren't served properly, well, I'm going to fix that within a year. That's not going to be incurable. If in raising certain issues, moving to dismiss, the court actually, you file affidavits, you file additional material outside the face of the complaint, that can actually convert a motion to dismiss to one for summary judgment. And the case could be over, the whole case could be over either by way of a motion to dismiss, a motion for summary judgment, very, very quickly. So you want to be careful how the court is actually treating that motion as well. Sometimes, some defendants' attorneys will file a motion to dismiss or in the alternative for summary judgment, and you better have some information to come to dismiss various counts. I'd say it's utilized about half the time. As is summary judgment, by the way, from the same standpoint as the defendant. I almost don't understand, with the modern standard on summary judgment, why more defense attorneys don't file summary judgment, because it's a pretty elastic standard, even though the rule doesn't seem to indicate it is. So I would do that more often as well, but I see that used in about half the cases. Okay? Questions on motion to dismiss? The big key, pointed out, is it gives you time to marshal the information so that you can properly file an answer. Otherwise, you're going to file an answer in all likelihood, deny. But remember to plead your affirmative defenses and remember to really investigate it. The problem is you have 20 days to file an answer. Oftentimes, you haven't even seen that client until the last of those the second half of those 10 days. And you gotta make your fee arrangements, you gotta do other things as well before you're gonna be putting your name on the pleading and filing it with the court. So there's a bunch of things that need to get done and get done in rapid order.
But if you file one claim where in good faith you can file
One of the counts
It
legitimately
tells
has a motion to dismiss, it would toll the entire time for filing the answer to the complaint, yes. Yep. Oh yeah, well listen, you know, I call you up and I say, listen, I need 30, listen, I gotta get rid of that, I do that too much. I need 30 days, can you give me an extension of 30 days to file an answer? As for most of the times, that's professional courtesy, we're gonna give each other, even though it's gonna delay the case a little bit, but that's just understood. You say, no, I won't. Now listen, I can get 30 days, I can get 30 days, I can get more than 30 days for filing a motion to dismiss. Or I can go in and ask the court, can I get a 30-day extension to file a response because I've just been retained to have to investigate the matter consistent with Rule 11. I can get it either way. If I don't feel like asking the court, I'll file a motion, I'll look at the count, I'll look at your counts, find something that's weaker than others, and I'll file a motion to dismiss, and now I'll get 60 days. And now you'll have to file a response to the motion to dismiss. And so, yes, and I might do it, just especially under those circumstances. I asked you for an extension, you wouldn't give me what would normally we would extend to one another as courtesy. I'm going to take a shot at 5 and 6 then, and I'll see if those counts are as weaker than I might think. If the judge agrees with me, off we go. So, and that's the important thing I think about the rules as well, is especially as you guys begin to practice, it's even more important to know the rules well and where the play is within them, because people will try to push you around and try to get you to agree to things that they wouldn't expect more seasoned attorneys do. And the other thing, unfortunately, is that you guys will tend to do things at times that more seasoned attorneys. We're now caught up and on section 6, and we have to talk about motions to dismiss tonight in a couple of cases. And I do want to mention to you that for next class, I hope to be back, but I am on the Human Rights Commission at Baldpate Hospital, and they meet quarterly, and their meeting is next Thursday. If it runs long, I will call front office and have them tell you that. And so, it doesn't look like I'll get back. I'll let them know that. We'll finish the cases that we have the next time we meet. But I hope and anticipate that we'll get back. It's just I don't know the agenda yet. So part of it depends on how lengthy the agenda is and how what's been going on at the hospital in that time period. So we'll have to play it somewhat by ear. But let's talk a little bit about motions to dismiss under Rule 12. Which ends up being a really important motion for a bunch of different reasons in civil litigation. One of the main reasons, and it's not the reason why it's used, but it has some real benefit here, is that when I file a motion to dismiss under Rule 12, it delays the time I'm required to file an answer. So a motion to dismiss, until that motion is acted upon, I don't have to file an answer. And so what sometimes it's helpful is, in order for you to be able to gather additional information and facts, in order to plead either the answer and or any counterclaim that you might plead. So you really should start to think about the motion to dismiss as a useful tool in your arsenal. I call it the first of your 3 testing motions, and it can test various procedural and substantive deficiencies in the complaint. Are we in the right court? Has the defendant been properly served? Is this the right forum that the defendant can be accountable in? Is it the appropriate venue? Are there problems with the complaint itself? And it's not just the complaint. I know when I talk to you guys about the rule, I always say the complaint. But more often than not, there are multiple counts in most civil complaints. It's usually never a simple count, breach of contract. If we've got a breach of contract, oftentimes we look to see